Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar Form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again, 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says, for Raila Amolo Odinga, 244 votes. For Mr. William Samoei Ruto, 38. What happened to the other votes? Something is fundamentally wrong. And this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IEBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Issa Juma of Super Wanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role. That what 138(3)(c) means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IEBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Maina Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more, and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. They were on board with every other commissioner. They spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important. They did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response. They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided we will appoint another lawyer on behalf of the IEBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday, we're going to have 200 petitions in 5 years. Why? Because there are no consequences. We can all come here and be on television. There are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kioko Kilukumi will now address you on the 9th issue.
Your Ladyship, the Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, my name is Kioko Kilukumi, and I appear for the first respondent. Our team leader has asked me to deal with the issue raised by Mr. George Oraro, Senior Counsel, in regard to the affidavits filed by Joseph Kinyua and Kennedy Keara. This court did direct that the first respondent is at liberty to come and place the facts he has before this court, not through affidavits, but we've been given the permission to place the facts because time was running and the court directed we have that time. The first respondent wishes to place it on record that under Article 240 of the Kenya Constitution, there is established a National Security Council. And he is, by virtue of being the substantive deputy president, is entitled to sit in that council. He says, in the last 5 years, the council has not sat and discussed anything to do with elections. He further says that matters of election are vested in an independent body, and that independent body is the IEBC. That is the body that has the constitutional mandate to deal with elections. He further says, during that period of 5 years, the council has not asked the National Security Advisory Committee to deal with IEBC on any matter relating to elections. And he takes the position that the visit by members of the National Security Advisory Committee to IEBC at the Tallying Center was an interference with the functions of IEBC. And it was calculated, given the membership who was sent there, it was designed and calculated to intimidate the chair of the IEBC and to seek to influence the outcome of the election. We ask the court to note that these affidavits were provoked by what Mr. Chebukati said in his affidavit sworn on the 26th of August, 2022. From paragraphs 55 to paragraph 75, he has given a subheading and he calls it an attempt to subvert the will of the people. And we invite the court to consider those paragraphs and to see which party is telling you the truth. We wish to refer you specifically to paragraph 66 in that affidavit. And it is an important averment, an important deposition in that affidavit. He says, Mr. Chebukati, when he was at the National Tallying Center, members of the National Security Advisory Committee visited him, and he sat with them after 2 p.m. It is important to contextualize the time. We are talking of the 15th of August, Bomas of Kenya. There is a meeting and this meeting is attended by all the commissioners. All the 7 commissioners are there. The fact of that meeting is not disputed, or the affidavits filed regarding that matter make critical admissions. The first admission is that indeed Joseph Kinyua telephoned Chebukati and told him, "I'm sending my members to you." That's an admission. The second admission is that all the commissioners, and these are the affidavits from Mr. Joseph Kinyua and Mr. Kenneth Kiara, all the commissioners were present. It is past 2 p.m. It doesn't say how long this meeting took. The country had been put on notice. Elections results will be declared at 3 p.m. And once you look at the paragraph I've referred the court to, Mr. Chebukati says the message from this powerful committee was simple: declare these elections in favor of the petitioner, the first petitioner, in petition number 5. If you are not able to do so, please massage the electoral data and force a runoff. And now that issue was discussed openly by the members of this powerful committee and all the commissioners in IEBC. The 4 commissioners made it very clear the suggestion from the Security Committee is reasonable and we should actually accommodate it. We should think of doing it. The 3 commissioners, and all of them have sworn affidavit attesting to that. The 3 commissioners said, nothing doing. We will declare these elections in accordance with the Constitution of Kenya, and we will declare the legitimate results. And so we ask the court, you do not have the advantage of witnesses being cross-examined, but you have the ability to look at all the accounts and see which account is more probable. The meeting starts past 2. Elections were to be declared at 3. At 4 p.m., the 4 commissioners are in the Serena Hotel. Our TV screens has been split. One side says 4 commissioners are disowning the results. The other screen is showing us chaos in Bomas, attack on the chair of IEBC, attack on the 2 other commissioners. Do you believe, will this court believe, that members of the National Security Advisory Committee was going to discuss matters of security when in less than 1 hour, 2 hours, the electoral commissioners are being assaulted, and this is being broadcast live? Assaulted, a cognizable offense. Police are in Bomas of Kenya. Nobody's arrested, and the people who are doing these attacks are well known. So we ask you to consider that fact in trying to see which account is likely to be true. The commissioners at Serena Hotel opened by saying, we've conducted a very good election. It's only gone bad towards the end. You will ask yourselves, does somebody disown results which he doesn't know? Do you believe these commissioners did not know what the outcome has been? We submit they knew the result, and that is why they were disowning it. We also ask the court to consider these 4 commissioners, apart from the press they did on 15th of September. They again did it on 16th, the following day, 16th of August. Was it a coincidence that again our TV screens were split into two? You see the 4 commissioners, and you see the first petitioner, and they are speaking, the language they are talking, the words they are using are strikingly similar. Is it a coincidence? These are matters we invite the court to consider in trying to ask itself, which account do we believe? I urge this court to believe the account given by the 3 commissioners. The will of the people was just about to be subverted. And the attempt was unsuccessful because the 3 commissioners stood by their oath of office and faithfully executed what was expected of them by the Constitution of Kenya. This split between the commission, the court has posed questions. When did it happen? Once you look at the affidavit of Chebukati and the timing, at past 2, they are in a meeting. And by 4, they are in Serena Hotel. You will come to the inescapable conclusion that the division in IEBC was caused by the National Security and Advisory Committee. And indeed, they hijacked the 4. That is why the 4 would approach this court for the very first time in the history of this country, approach the court to seek nullification of an election that they superintended and that they said they conducted a very good election. We ask the court to take into account that there appears to have been a mistaken impression that presidential elections are determined by commissioners. Anybody who wants to become the president of Kenya must have in his corner the Kenyan electorate. And that voter who turns up in the polling station, not the one who stays away. And if you convince that voter who turns out and you get the majority of votes, you become the president. 7 commissioners cannot make you the president. 4 commissioners cannot make you the president. Who makes the decision as to who becomes the president of the Republic of Kenya? It is our humble submission. It is not the commission. It is not any of the commissioners. It is the electorate. It is the people of Kenya. And therefore, this narrative that we are the majority, we needed to sit down and make a decision, that decision as to who becomes the president of Kenya does not lie with the commission. Theirs is to midwife the process, and that is all they can do. We wish to submit that the first respondent won these elections fair and square. You've had the submissions and the evidence that has been presented by the midwife, IEBC. And they have made it absolutely clear that this election was conducted in accordance with the Constitution. It was computed in accordance with the Constitution. And they have a very clear winner as to who obtained the highest number of votes and made all the requirements required by Article 138(4). For that reason, we ask this court to consider that this petition is the consolidated petition are founded, they are all anchored on fiction. They are all anchored in forgeries. They are anchored in fraud. that clearly tells you these petitions are built on sinking sand, and for that reason, they must fail. I wish to ask the court amply to reflect on the ruling of King Solomon. Just like King Solomon before you, you have two gentlemen here, each one claiming a baby. The baby they are claiming is the outcome of the 2022 election petition. During the days of Solomon, there was no DNA, and therefore he could not easily make up a decision as to whose baby is this. Today, you don't have mothers competing for this baby. You have two gentlemen, each one of them claiming the baby. What does the petitioner ask you to do? Just like the days of Solomon, he is telling you, give me the baby is mine. And then he goes on to tell you, if you cannot give me the baby, slice it into two. We can call this baby Victoria. We can call this baby Victor. But the more gender-neutral term, let's call this baby Victory. Baby Victory has a clear DNA. Baby Victory, his DNA is captured in the original Forms 34A. His DNA is captured also in Forms 34B. That baby belongs to Honorable William Samoei Ruto. Give him his baby. Don't divide the baby. The petitioner here is telling you, you either give me the baby or cut the baby into two. Nullify the election. Solomon used that in this year to know who was the true mother of this child, because no mother would want a baby chopped into two. And so by the petitioner coming to tell you here, if you don't give me the baby, slice the baby into two, you already know whose baby the victory of 2022 presidential election is. I urge the court to give the baby to the legitimate and lawful father, who is Honorable William Samoei Ruto. Thank you very much. I'm sorry, Your Ladyship, the Chief Justice, Justices of the Supreme Court, I wanted to yield the floor to my senior friend, Gatia, Senior Counsel. Thank you.
Madam Chief Justice, my duty is to make closing submissions, as I also deal with the last issue. What are the appropriate reliefs? Yes. Oh. I start by apologizing. I left out two members of my team, two lawyers who have worked very hard, Rose Thiongo and Ham Langat, Mr. Ham Langat. I think in fairness, it's good I place them on record. They have done a stirring performance, and this is part of the mentorship we should do. Madam Chief Justice, let me also start by apologizing that I did not place on record the fact that we did file written submissions on 27th August this year, and we rely on those written submissions. We took lots of time to actually develop almost a treatise on the origin of Election Act. We went to 1870 in England, where we found the first codification of the Election Act, and the subsequent development and the hesitation by apex courts in not disturbing electoral victory. I would request you, in the fullness of time, please look at it. I should also, in fairness, indicate that the authority I referred to from Ghana decided last year the Mahana decision is authority number 5 in our list of authorities. And again, this, Madam Chief Justice, let me say this because I ought to acknowledge it. Judges in Ghana quoted with approval one of your judges. Writing of this apex court are now being quoted with approval in the continent of Africa. And if I could say so, this is also because of the very vibrant advocacy by my learned friends. So if we could participate in enriching the jurisprudence in Kenya and Africa, so be it. I now go to a very brief response overview. You have a petition before you by Julia, I think is now number 7, the one about special group of people, 500,000, who allegedly were denied the right to vote. And this is what we call not now fiction, but theory, pleading or drafting a petition on the basis of abstract principles. The so-called 500 people, not a single one of them have filed an affidavit to say because they were working for IEBC or were working in any hospital, they were deprived an opportunity to vote. In other words, this court must also try to establish some rules of engagement. Are we going to be holding this country at ransom as we process these petitions, which are, to say in very modest terms, very frivolous? One comes and says 500 people are denied an opportunity to vote, and then he gets away with it. Juria is a very good example of what states in America have now resolved to do. They do punish a pleader who files a pleading with the full knowledge that what is being pleaded is incorrect. I go to another area of so-called suppression of votes. This is another constant denominator, that the suppression of vote, because one level of votes was not held. And the question is, where is the empirical evidence? Empirical evidence that because there is no voting for a senator, then the turnout for votes for the presidency are suppressed. And suppressed in relation to only one candidate, not both candidates. My learned friends have talked about what yesterday was being called dysfunctional IEBC. It is not dysfunctional IEBC. It was a functional IEBC until 3 p.m. on 15th. On 15th August, towards 3 p.m., some commissioners were hijacked with their free will, and they opted to walk out from their brothers and sisters. There is a point that concerns me as a regular practitioner in this court, in these electoral cycles. And this is this. For how long are we going to allow our political class to advance self-interest, and to hold this country in perpetuity of uncertainty? That is something I think, Madam CJ, you now have an opportunity under Section 3 of your Act. The first fundamental in Section 3 is your true north, is supremacy of the Constitution, your true north being the supremacy of the Constitution, and then other factor to consider is that this court is required to help us develop even a political path for this country. Those two becomes very important aids in how we deal with the political class. I'll come to that towards the end. But it is something of concern, because unless it is captured early, I do not see great hope in the way we are proceeding. Madam CJ, first and second respondents are very ordinary Kenyans, very ordinary, humble origin, and this is a country I always have thought is a country of hope and opportunity. Hope and opportunity for each and every Kenyan. A child from humble origin ought to aspire one day to be a Chief Justice of this country. A child of very humble origin ought to aspire to be a top surgeon in this country. I say all this because, in all fairness, unless we show hope and opportunity to all, then we'll be missing an important aspect of our growth. There were questions that were posed to my learned friends. Since I won't have another opportunity, allow me just a few minutes to deal with a few of them. I'll start with the first question about rejected votes. It was posed by one of the judges. Rejected votes is a point we litigated in Raila 1, that is 2013, not as a side issue, but it was the subject of a petition. In 2013, there was a petition dealing with nothing but rejected votes. Rejected votes, Madam CJ, can be the third candidate. It's very easy for rejected votes to be the third candidate. And in 2013 at Bomas, where I had the pleasure and privilege of being the chief agent for the candidate, it became quite obvious that rejected candidates will be the third candidate in that contest. And if they were to be factored, then the whole purpose of rejected votes is to bring down the victory of the candidate who would otherwise have won. So it is a point we litigated at length. Some of my learned friends, my seniors, we litigated at length, and this court held and found that what is to be considered are the valid votes cast. So in my submission, that is a point that has been dealt with. It was again repeated by the court in Ghana. Last year, they rejected the notion of considering rejected votes in the final tally. As a matter of fact, now that I remember, I'm getting a little older, I was clearer then in 2013, it is a misconception to call them rejected votes. It is actually rejected ballot, because a vote is that which is valid, which expresses a choice. So those so-called rejected votes are actually rejected ballot papers. The same holds true for spoiled ballots, and the same holds true for stray ballots. As fate would have it, you will not even know about the stray ballots at the point that the tallying is going on. I associate myself with the submissions made by my learned friends, IEBC. They are the ones who conducted the election. It is not within our place to supplement their submissions. We wish to associate ourselves with the submissions, particularly as regards how the election was conducted. I come to what is the elephant in the room, to quote Tata, who I have never quoted before. What is the way forward? On the one hand, you are being requested by many of my learned friends, actually all of them in unison. It's the first time I have seen so many lawyers making the same request: nullification of the election. Almost reminds me of the trial of Christ. Crucify him, nullify the election. After nullification of the election, no solution is provided. But all they request is nullify the election. As you consider the rival position, I will request you to consider the following. In the event you nullify the election, you will effectively be rejecting the substantive truth that the majority of voters in this country express their free choice. While considering that plea of nullify the election, we shall be acceding to a very dangerous trend in this country, that presidential elections are to be held, and if I'm aggrieved, not because of any error, but I want to hold the country at ransom, I will walk to the Supreme Court and the election will be nullified. While considering that request, please also consider the far-reaching consequences that we all participated, we all experienced in 2017. That is on the one hand. On the other hand, the first and second respondent come to you with a request. The request is, voters did exercise their right. Hold them to that covenant. The covenant is they made a choice. Do allow the country to now move forward. We cannot and cannot afford election mode in perpetuity. I think I have said enough to demonstrate where my mind is. It is time for finality and stability. Finality and stability. In doing so, Madam Chief Justice, you'll be sending yet another signal to the political class. And here I am not finger-pointing anybody. As I said in 2013, what I say for this client is what I'll say for the next client who is in that class. The country does not belong to them. This country belongs to all of us. And since the country belongs to all of us, no person should consider that there is an entitlement. Considering that there is an entitlement is to engage in an illusion. That illusion ought to be replaced by reality. Reality is that it is voters who make their choice. And once voters have made their choice, let us inculcate a culture that my brothers and sisters on this side are now used to. We walk to our court, we may think the law is on our side, we may think we are entitled to victory, but we accept the verdict of the court, because much as we may think we are eloquent litigators, the final word is always with the court. With those comments, may I very humbly and respectfully request this court to let this cycle come to an end so that we can get back to our business, the business of developing our country. With those remarks, I would wish to close and to donate the 30 minutes to the court, because we are patriotic enough to know that it's not really in the interest of this country to engage this never-ending circle of litigation. Thank you very much. Unless you have any questions for us, that's the end of our case.
Thank you very much. We appreciate the donation and the appreciation that this time that we have is very, very tight, because for us, the work actually begins when we finish all this. The bench will have questions to those submissions that have been made today. But I think there are a few who might also want to add some questions to the petitioners, especially the commissioners who are supporting the petition. I think what we want to do now is take a short health break, resume at 5:20, and this is going to be the order of business. We will ask questions to the petitioners and the commissioners who are supporting the petition. They will still respond tomorrow when they are doing their responses. But for the respondents, the first and the other respondents, we will request them to answer today the questions. We will also share the report on the scrutiny and the orders that were issued by this court on the discovery issues, the application by the petitioners. I think it was the first petitioner, Kerif Karifa, and the youth advocacy. They had applications for scrutiny. That report is being finalized. It will be shared. And tomorrow we will give you an opportunity to respond to the report. So we will adjourn for just 20 minutes.